Welcome to Week 2, Class 4, Video 1, where we're going to be discussing the right to destroy. Before we do that, I have a question for you. When was the last time you destroyed property, and why did you destroy it? Now, you may not have had the luxury of destroying any homes lately, but we all destroy property of some sort. We do recycle paper, throw away cans, or recycle them, hopefully. Property destruction is something that we all commonly engage in, and we typically do so out of necessity or because there is some benefit to society for the destruction. The first case we are going to discuss is Eyerman v. Mercantile Trust Co. And the purpose of including this case is to discuss how much autonomy an owner should have over their property. First, let's discuss the facts. So the plaintiff, who were not the beneficiaries of Johnston's will, but were members of the community and of the neighborhood, they appealed a denial of a petition to seek injunction to prevent the demolition of the house commonly referred to as number 4 Kingsbury Place. And Kingsbury Place was in a prestigious historic neighborhood in St. Louis, and it was actually a city landmark. The owner, a lady by the last name of Johnston, had died, and in her will, she ordered the destruction of the house. Now, the house was worth around $40,000 at the time, and the estate would have lost $39,350 of its value if they had gone through and destroyed it. The claims that the plaintiffs made was that destroying the home would adversely affect their property rights. The second claim they made was that it violated terms of the subdivision. The third claim that they made was that its demolition would result in a private nuisance. And the fourth claim was that destroying the home was contrary to public policy. And it was this fourth claim that the court focused on. You can find the issue at the top of page 84, restated by the court, which was whether number 4 Kingsbury Place should be raised as an issue of public policy involving individual property rights and the community at large. The rule of this case is actually a little buried. So if you go to page 86, you'll find the rule in the second paragraph. The court says that where there is no guiding statute or constitutional provision, the court must rely on a determination of public policy. Well, what was in the best interest of public policy? How does the court know? If you go back up to the first paragraph on that page, the court defines what being against public policy means. And its definition is that it conflicts with the morals of the time and contravenes any established interest of society. It is, if you go down to the bottom of the paragraph, the court says that it is injurious to the interests of the state apart from illegality or immorality. So that is the rule that the court is applying. In applying that rule, the court makes a number of arguments. It raises a number of considerations or factors that influence its decision. I'd like you to take a moment and, in a sentence each, identify what each of those factors are. The court lists, I have about 7 factors that it considered. The first was that demolishing the building would result in loss to the estate. The second was that destroying the property would depreciate the neighboring home values. The third was that Kingsbury Place is a landmark. The fourth was that an empty lot would be like missing a front tooth and would again depreciate the neighborhood. The fifth consideration was the pressing need for community dwellings. So basically, it cited a housing shortage. The sixth reason that it cited was that the owner of the property did not give a reason as to why she wanted the property destroyed. And the seventh reason was that the owner of the property is not a living person. She is indeed deceased. So what legal standard could we pull from this case? Well, if you go to page 86, third paragraph, the court says, a well-ordered society cannot tolerate the waste and destruction of resources when such acts directly affect important interests of other members of that society. So in other words, here the court is using a balancing test where it balances the interests of the property owner against the interests of society. That is the legal standard in this case. Before we go into discussing the dissent, I'd like to unpack the case a little bit more. Well, the first question I have for you is, the court cites a lack of reason as a factor in its determination. Why should intent matter to the court? Intent is an important factor of consideration for the court because the court uses a balancing test to balance the interests of society against the interests of the owner in destroying the property. And it can't determine what the interests of the owner are if it is not aware of the intent of the owner. So therefore, intent is a consideration that the court is taking. Since the court appears to care about the intent of the homeowner, what do you think would be sufficient justifications to destroy a house? Some justifications you could have listed are there's a dangerous condition in the house that is difficult to remedy, and that the house was the site of a tragedy perhaps, or a very violent crime. But those aren't all of the justifications. Those are just a couple. And I frankly find the dangerous condition in the house the most convincing. My next question is, what are the philosophical views of the majority? So try to remember the philosophical theories used to justify property laws. And I'd like you to tell me what you think, how you would categorize the philosophical views of the majority. The philosophical views of the majority that were used could be classified as utilitarian because the court balanced the rights of society versus those of the individual, and it ruled in a way that accounted for the best interests of society at large. So it would be the utilitarian approach. Now, does it matter that the destruction was called for after the owner's death, since it was in her will, rather than when she was alive? Or put another way, had she have been alive, would the court have ruled differently? The court would have likely ruled differently had she have been alive. The court said, while living, a person may manage, use, or dispose of his property or his money or property with fewer restraints than a decedent by will. One is generally restrained from wasteful expenditure or destructive inclinations by the natural desire to enjoy his property or to accumulate it during his lifetime. Such considerations, however, have not tempered the extravagance or eccentricity of the testamentary disposition here, on which there is no check except the courts. So here the court is saying that a person who is alive has more property rights, less restraints than someone who is deceased. Let's unpack the dissent. What do you think was the dissent's position? The dissent basically analyzed the same facts and came to a different conclusion. According to the dissent, the testator should have, or Ms. Johnston, should have had the right to destroy the house upon her death. And according to the dissent, the law favors the free and untrammeled use of real property as long as it does not substantially impair another's right to peaceably enjoy his property. Who do you agree with? The majority or the dissent? Now let's do some problems. In light of Eyerman and other materials presented, should the law recognize the owner's right to destroy under the following circumstances? A owns a beautiful, world-famous painting by Claude Monet, which when publicly exhibited helped millions of people develop a greater appreciation for fine art. A dies, leaving a will that instructs his executor to burn the painting and deposit its ashes in his grave. Should the law recognize the owner's right to destroy under the following circumstances? The author will probably not be able to be allowed to destroy the property. Let's look at why. These facts are pretty close to Eyerman's case. We have a testator here, and they gave the instruction to destroy a valuable asset at their death. Here, just like Eyerman, there's no reason for the destruction, and the destruction will injure a third party, society as a whole. Aside from that, there may be some protections under VARA, which we will discuss later. Our second problem. B owns a 100-acre tract of prize-winning orange groves. On a whim, B decides to cut down the trees with a chainsaw, which will reduce the value of the land by 90%. Does B have the right to destroy his orange groves? The answer to this is probably yes. This one's a little bit of a harder problem because there are some differences here between the facts presented and those in Eyerman. First of all, B is still alive, so a living owner has much greater rights to destroy than somebody who's deceased. There is also no indication here that there are any third-party interests that will be adversely affected by B cutting down the orange groves. The orange trees aren't particularly unique, so I think the court would allow the destruction in this case. Problem 3. C sells her Florida home for $2 million and uses all the money to purchase rare stamps. As a public art project, C then begins burning the stamps one by one. C's 4 children protest this wanton destruction, but C ignores their pleas. Should C have the right to destroy the stamps? All right, for the answer, let's start by trying to apply the Eyerman approach to this case. So on the one hand here, C is still alive, so courts would grant her a great deal of autonomy over her property, greater than that of somebody who is deceased. C does have a reason here for her destruction. It's arguably weak reason, but it's for a public art project, and some might argue that the purpose of art is to shock and surprise. So perhaps that is enough of an interest or reason. But on the other hand, there are some adverse effects here that are pretty high, right? So she appears to have sold her home for $2 million and then used all her money to purchase these. If C is wealthy, then maybe she does have money to burn, literally. But if she's not wealthy, then she is impoverishing herself and her children, and that is a public policy consideration. That might sway a court to deciding that it is in the public's benefit to prevent her from burning her stamps. The question is whether this interest should trump C's autonomy. And it's unclear. It's unclear. On the one hand, C has a reason and it's weak, but that reason would be balanced with the interests of society. I would argue that the court would likely cause her to stop unless a case can be made that she is really trying to be an artist.